In this video, I'm going to talk about interstate relationships, the relationship between the many states. Part of the relationship is defined by something in the Constitution that's referred to as the full faith and credit clause. It deals with other issues, but one of the things that the full faith and credit clause does is it says that states must respect the public acts, records, and judicial proceedings of other states. Let me give you some examples of what that means. I'm not sure if everybody's familiar with the term extradition. When you extradite somebody, it means that in the case of states, a person was in one state. They were accused of committing a crime, but before they were apprehended, they fled to another state. If that happens, a state has to extradite that person back to the state where they were accused of committing a crime. That's what we mean by the extradition of criminals. So if I'm a person in California and I break a law in California and then I flee to Texas, right? And the state of California has issued a warrant for my arrest, the state of Texas is required to extradite me, to return me to California so I can face judgment on the part of the state of California. There's been a judicial proceeding where a warrant was issued, and the states, all the other states, have to respect that. That's part of the full faith and credit clause. Another aspect of the full faith and credit clause is the definition of marriage. So for example, I was originally married in California. During the time that I was married, if I went with my wife to Nevada or Wyoming or New York and we moved there, I wouldn't have to get remarried in any one of those states because I've been married in California. All of the other states would have to respect that marriage license, the public act and the record of the marriage. So if I moved to a bunch of different states, I wouldn't have to get married in each one of those states again. My marriage would have to be recognized by the state. So that's the first example. The second example is something that has been touched on before, and that is same-sex marriage. Now, before I proceed with this, I want to tell you a story about something that happened with a few years back at College of the Canyons. I was speaking with a dean about the question of same-sex marriage, and at one point she kind of looked at me with a strange look, and I was a bit taken back, and I asked her what. This dean happened to be gay. And she said to me, Phil, I don't same-sex walk my dog, and I don't same-sex park my car. I walk my dog, and I park my car. And I don't get same-sex married, I just get married. Now, I had never heard that before, and quite frankly, I didn't quite know how to react to that, but I understood her point, that at the point at which we were talking, marriage was legal everywhere in the United States, both same-sex and traditional marriage. And so for her, characterizing it as something other than marriage was problematic. So each time I talk about this lecture and this part of the lecture, I always refer back to that conversation because I thought it was a really insightful thing. So in any case, let's move on. As we talked about in previous lectures, there was a point at which the state of Hawaii began to permit marriages of same-sex couples. Later, the laws were changed to prohibit that, but then the state of Massachusetts also made same-sex marriages legal. Well, how does that work? If a marriage is legal in one state, and in this case we're talking about a same-sex marriage, if that couple moves to another state, according to the full faith and credit clause, the other state has to recognize that marriage. Now, this issue had been dealt with before in earlier years in a very famous case called Loving versus Virginia. There was a couple, a black and white couple, that was married in a state that permitted interracial marriages. And then they moved to Virginia, this couple. And when they moved to Virginia, Virginia refused to accept them as being a married couple. And that eventually became a court case. In the case of same-sex marriage, what happened is when the first state started permitting same-sex marriage, other states began to change their constitutions so that their constitution stated explicitly that their state only recognized marriage between a man and a woman. And this was left as a kind of stalemate for quite a while, because on the one hand, states get to define marriage. So each state gets to define how they view marriage. On the other hand, the full faith and credit clause states that if somebody is married in one locale and they move to another one, that state has to recognize that. Ultimately, this was decided in 2014 when a federal court ruled that prohibitions against same-sex marriage were unconstitutional. But before that point, it was unclear as to how this would work out, because again, in our federalist system, where each state has the authority to determine what marriage is, it's not always easy to tell what holds precedence. Does the state's constitution, which limits marriage to just a man and a woman, does that hold precedence over what the Constitution says, when the Constitution also gives the states the right to define what marriage is through the 10th Amendment? This is, again, what makes federalism complicated. When power is dispersed very widely and when states have a lot of power themselves, this is what makes our system confusing sometimes, but also dynamic sometimes as well. So in the last video, I'm going to talk about the division of power between the national and state governments and some examples of the ways in which it's constantly being negotiated.